away someone's children. And you just said that's obviously not okay to do.
According to our moral compass and our ethical guidelines, but what we're here to decide is the constitutionality of it, and we look to the courts.
You mean due process is somehow consistent with a government official introducing perjured testimony and false? How is that consistent? I mean, I hate to get pumped up about this, but I'm just staggered by the claim that people in the shoes of your clients wouldn't be on notice that you can't use perjury and false evidence to take away somebody's children. That to me is mind-boggling.
In criminal proceedings, we know this to be true because that...
No, like criminal proceedings, it's a court proceeding with a liberty interest, a fundamental liberty interest at stake.
And on the reverse side, the state...
And you're telling us that these officials who do this all the time couldn't be on notice that you can't commit perjury and put in false evidence.
I understand broadly the principle that common sense tells us that lying is wrong. And lying to...
Yeah, but it's more than common sense. We're not using common sense. We're using the statutes, for example, against this kind of behavior.
I was not presented, I have not been seen any federal law, case law, or law that tells me that in this situation that we were faced in, which is what we have to
say your clients hired 6 people to be actors and to go into court and say, we're neighbors and we saw all this terrible stuff. And then your clients presented those witnesses in court. You're telling me that they would have no reason to believe that you can't do that because there was no federal case that says you can't bring actors into court to swear falsely against somebody.
But again, here we're appealing to sort of a broader definition of what is a clearly established right. I mean, we have to find the clearly established right in the context that our social workers were presented with, which was they were faced with a court order.
You know, again, I can't even believe for a microsecond that a caseworker wouldn't understand you can't lie and put in false evidence.
Let me ask the question a different way, counsel. Was there anything you know of that told social workers that they should lie and they should create false evidence in a court proceeding?
No, and of course, you know, that is, we contend that that's not what happened here.
I understand. Look,
We're stuck with the facts in the light most favorable.
And to be clear, we are only speaking that
Right.
we accept the pleadings as alleged. We are not saying any of this is true. I want to be very clear about that. But
Right.
That's what we're dealing with right now. Is there anything, I mean, look, you've got your clients, you're doing your best to represent them here. But from our perspective, you see where we're coming from here. So help us. Okay, we've talked about Costanich, and we've said that case there's some language in there which I understand what you're pointing to. I got you. But as Judge Friedland and Judge Trout both said, it also does have a different interest. So is there any case besides Costanich that you can point to and say, here's Ninth Circuit, this is the answer?
Well, what I would contend, Your Honor, is that was plaintiff's burden to do when it came to law.
No, I understand that's your argument, but just for your sake, because you reached to Costanich, which if I were in your shoes, I'd be reaching for it too, as hard as I possibly can. Is there another case? You got one hand kind of on the ledge here with Costanich. Is there another hand you can grab another Ninth Circuit case where you've got a firm grasp? You can say, see, I've got it.
In terms of another Ninth Circuit case that instructs social workers to lie and cheat.
Or at least sets a time period. At least sets a time period that says, as of this date, you can't do this anymore.
Other than Costanich, Your Honor, I do not have any such case in front of me.
As a matter of fact, Snell precedes all of this, and we have cited Snell with approval on many occasions.
I understood, Your Honor. Snell did precede this.
And we've embraced Snell in our published opinions.
In the context of criminal proceedings, yes, that is true.
Snell wasn't a criminal proceeding.
I believe Snell involved a criminal proceeding, an affidavit for a warrant. I believe was the underlying issue.
We can look that up if there's any question about that. But you mentioned nothing other than Costanich. Now they're going to come up and they're going to talk about the Green case, Green versus Camreta. What's your response? And look, and I will acknowledge our case law is not entirely clear on this. Okay, so I don't fault you for having to dance around these two cases. But Green, what's your response to Green?
Green does not clearly establish the law as it was in the year 2000. Green was decided in 2009 involving conduct in 2003.
But if all those cases talked about conduct that was previous to the conduct in this case, they referred to cases that referred to conduct that was earlier than what happened in this case.
Correct, but again, in the context of criminal proceedings.
But Green cites them as establishing a principle beyond criminal, right?
Right.
It does. And, you know, one thing that we read in Costanage, and I understand we're sort of beyond that, but, you know, there is a difference between civil child abuse proceedings and criminal proceedings.
But doesn't Green stand for the proposition that that's not true?
Even if it did, again, it is post-conduct authority that our clients would not have been aware of. And Your Honors raise a good point when you say the case law isn't clear. I mean, our own district court judge made that comment that, you know, as between Green and Costanage, it was very difficult to reconcile. And I would submit that if it's difficult for courts and it's difficult for judges, it certainly would be difficult for us.
Can we back up for a second and talk about whether we even get to this issue? Because why do you think that qualified immunity wasn't litigated in the state court? Why aren't we bound by what the state court said about qualified immunity?
Well, the state court's analysis in terms of qualified immunity, I don't think was did not comport with the federal court analysis.
I mean, that may be, but isn't that not a factor in estoppel analysis? I mean, aren't we bound even if the state court got it wrong, as long as it had jurisdiction, it decided the issue? If it cited the wrong cases or said the wrong thing, we're still bound by it as long as it was decided, aren't we?
I would submit that the issues were not identical that was submitted to the state court versus the issue here. Yes, the term qualified immunity was used, but the underlying, in our view, the case law had changed.
Wasn't the issue whether lying in court to deprive a familial relationship was clearly established? They didn't say clearly established, but wasn't there a question? Wasn't the question in state court whether there was qualified immunity for lying in court to deprive a familial relationship?
The question, correct. There was an issue of qualified immunity. Now, they did not do the two-pronged analysis. And
Right, but that gets to citing the wrong cases. So what's the difference in the issue that was decided?
Our argument here is that Costanage changed the lay of the land. And when there is a change in the law, California courts have ruled that collateral estoppel cannot
But
bind
that's
us.
when the change in the law is like, is this the statute that this is about, or is that the statute that this is about? The state court was talking about qualified immunity. Now, maybe they made a mistake, or maybe you think they cited the wrong cases, but there was no issue of like, now California law under this statute is totally different. It was still qualified immunity.
That is correct, but there was a change in the law in terms of the federal qualified immunity doctrine and how it applied to the facts of this case.
I mean, is your only basis for that Costanage, which we've earlier said we don't really think changed anything relevant?
It's Costanage, and it's also the fact that Green, which came out after the fact, you know, made these connections in terms of civil and criminal child abuse proceedings.
How is that relevant to what you think the state court did? I mean, your first response is the state court didn't really look at this the way the federal courts do anyway. So if we start there, then does it matter what Green and Costanage said?
It matters because the issue has changed, and if the issues are not identical, we don't have collateral estoppel.
But isn't the issue still qualified immunity for lying in court to deprive a familial relationship?
It is. The issue in the state court was the familial relationship of the mother. Here we are dealing with the familial relationship of the children, so that is a different aspect of the issue. There are different rights involved there. And the issue is the difference in the law, that the landscape of the law that changed after that.
Thank you, counsel. We will go ahead and you got a lot of questions, so we'll give you 2 minutes in rebuttal, okay?
Thank you.